Good morning, Mr. Crenshaw. Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 19th, 2025, in Harris County, Texas, officers were dispatched to a disturbance call. An officer met with the complaining witness who stated that the defendant has been staying with him off and on. The complaining witness advised that he came home and found garbage in the apartment, which the defendant denied having done. The complaining witness stated the defendant started recording him, accusing him of threatening the defendant. The defendant then put the phone in the complaining witness's face, and the complaining witness took the phone, at which point the defendant punched the complaining witness several times in the face, causing pain. The defendant then attempted to take an electric scooter, which eventually struck the complaining witness in the leg, causing pain. The officer observed the complaining witness to have multiple injuries on his face.
All right, Mr. Crenshaw, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have contact with the complaining witness in this case and not to be in possession of any weapons. You understand? I don't see that a MOA or a protective order has been issued. Do you? You see a tray protective order?
The stipulations of my bond. I know that.
On Crenshaw? Okay. I'm now entering in what's called a mattress order for emergency protection. This is a court order that identifies Mr. Montgomery as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is a stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where he lives or where he works. Do you understand?
Yes, sir.
If you violate this court order, the state can and probably will file a violation of a protective order. It's one of the worst cases you can pick up.
Yes, sir.
Do you understand? Do you have the ability to hire a lawyer, Mr. Crenshaw? Do you work?
Yes, sir. I'm currently looking for a job.
It's time.
Yes, sir.
We're going to make sure that that happens. So 2 weeks, I'm going to bring you back and I want to see what you have done to get a job. If you've done nothing, it's not going to go well for you.
Yes,
Do you
sir.
understand? All right. I'm going to appoint you a lawyer. I'm going to have you go to Victoria Center, reset. We will have you take a seat in the jury box. I'm going to get you bond conditions. Do not leave until you sign them.
Yes, sir.
You're not to have contact. You're not to be in possession of weapons. You understand?
Yes, sir.
Come on.
Let me take it.
Oh, good morning, sir. So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir.
Okay, Your Honor. On April 17th, 2025, in Harris County, Texas, a law enforcement officer made contact with the complaining witness who stated that she had a green light and the defendant's vehicle struck her on the driver's side. The complaining witness was transported to the hospital. A wheel witness stated that he saw the defendant driving at approximately 90 miles per hour and run the red light and hit the complaining witness's vehicle. The wheel witness followed the defendant and the defendant stopped a few hundred yards away from the scene. The wheel witness stated that he believed the defendant was attempting to flee, but only stopped due to mechanical issues with his vehicle. The law enforcement officer came into contact with the defendant and noticed slurred speech, an odor of alcoholic beverage, red bloodshot eyes, disorientation, and inability to follow instructions. The defendant admitted to driving. Standard field sobriety tests were conducted. A 6 out of 6 was recorded on the HGN, and the defendant refused the walk and turn and one leg stand. The defendant also refused to provide a specimen. A blood warrant was obtained and a blood draw was executed.
Jesse, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're using, I will revoke your bond and put you in jail. Do you understand? Can you look to see any prior DWIs and if he has a license, please?
No prior DWIs and no license is eligible, Your Honor.
Okay. As long as you have a valid Texas driver license and liability insurance, you may continue to drive. But like I said, don't consume alcohol. Don't use illegal drugs. You will be randomly tested. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with her and she'll tell you if and when you have to come back. For now, we'll have you go to Victoria, sign a reset. You'll get the pre-trial for your bond conditions and then you're free to go.
Thank you, Your Honor.
Mr. Brown?
So you are Ms. Martinez?
Yes, sir.
Ma'am, you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. No. I'm sorry, you're charged with DWI.
Yeah.
Okay, sorry, wrong Martinez. You're facing up to 6 months in jail and or a $2,000 fine. You're charged with DWI. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. If you cannot afford a lawyer will be appointed to represent. Okay.
Thank you, Your Honor. On August 5th, 2024, a law enforcement officer was dispatched to a major crash near the 3753 block of Highway 45 in Harris County, Texas. The law enforcement made contact with the witness. The witness stated she felt force pushing her car, causing her to spin out and crash. The law enforcement officer made contact with the defendant. The defendant stated she was operating the motor vehicle when the crash happened. The defendant stated she was driving home from a friend's house. The law enforcement officer observed red, watery, bloodshot eyes, slurred speech, belligerent behavior, aggression, and lack of cooperation. The defendant continued asking for ice packs after having received them and was crying, yelling, and swearing at the law enforcement officer throughout the investigation. Standard field sobriety tests were administered. A 2 out of 6 was recorded on the HGN, a 7 out of 8 on the walk and turn, and the one leg stand was refused. A blood search warrant was obtained and executed, and the blood results came back to a .12.
Prior DWI?
Let me look at the out of county.
Please.
Judge, I'm not seeing any prior DWIs here,
Okay. License?
and the license is eligible.
Martinez, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond, put you in jail. No more PR bonds. Do you understand, man? Do you have the ability to hire a lawyer?
No.
I can have you fill out an application. I need to know everything about you, how much money you make, how much money you have at the bank, what kind of car you're driving. I'll take a look to see whether you qualify.
Okay.
Deputy Miranda is going to give you an application. I'll have you sign a reset with Victoria. We'll have you take a seat. Eventually, you're going to meet with pretrial services, and then we'll take a look at your application. Please.
Mr. Graves?
Mr. Martinez, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, sir.
Thank you, Your Honor. On April 17th, 2025, in Harris County, Texas, an officer observed a motor vehicle traveling at a high rate of speed. He observed the vehicle brake hard to slow down. The officer then got behind the vehicle and observed it to have an expired registration as of January 2025. A traffic stop was conducted, and the defendant was identified by his Texas ID card. The officer approached the motor vehicle and observed the defendant in the driver's seat and the defendant to have glossy eyes, slurred speech, and an odor of alcoholic beverage. The defendant admitted to the officer that he had 5 to 6 beers prior to driving. The defendant stated he has a leg injury on his right leg. Standard field sobriety tests were conducted. A 4 out of 6 on the HGN, a 4 out of 8 on the walk and turn, a 1 out of 4 on the one leg stand. The defendant stated that despite his leg injury, he does work out and have an active life. The defendant stated he was a 5 out of 10 level of intoxication on a scale from 1 to 10. The DIC was read and the breath test strip was refused. A blood warrant was issued and the blood draw was executed.
Okay. Mr. Martinez, can you run his license, please?
Yes, Your Honor.
I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now, as a condition of your bond, not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you.
Yes,
So
sir.
if I find that you're using, I will put you in jail. No more PR bonds. Do you
Yes, sir.
understand?
Yes, sir.
I'm now placing a restriction on your license. You are not allowed to drive any vehicle that doesn't have an ignition interlock on it. If you're caught driving a vehicle that doesn't have one, I will put you in jail.
Yes, sir.
We are sending notice to DPS so that every single officer in the state knows that you're required to have an interlock in your car. So if you're caught wherever and you don't have one, officers will put you in jail.
Yes,
Do
sir.
you understand?
Yes, sir. Your Honor, can I speak?
Don't.
No, good. I got.
Don't. I don't want you to say a thing. Now's not the time. You have the right to remain silent, exercise that right. Just don't say anything. Don't. Do you have the ability to hire a lawyer, Mr. Martinez?
Not a problem.
Deputy Miranda is going to give you an application. We'll take a look to see whether you qualify. I need to know everything about you, where you work, how much money you're making, how much money you have at the bank, what kind of car you drive, how many cars, stocks, bonds, mutual funds, everything. And then I'll take a look to see whether you qualify.
Judge, we have that the license is not eligible.
You are not allowed to drive. You will be signing an affidavit with me today, Mr. Martinez, and I'm telling you now, I don't give a rat's behind what your excuses. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. This affidavit is what you're going to be signing, promising me you're not going to drive. Nothing in this world can justify you getting to a car and driving. Jesus comes down and needs to ride to church. Do not drive. You understand me?
Yes, sir.
Mr. Castillo,
Because you don't have a license, because you're not going to drive, I'm going to give you a portable device that you're going to take with you everywhere you go to prove to me that you're not consuming.
That's what I was gonna talk to you about. I was talking about my bond conditions.
Mr. Martinez, in the last 1.5 years, you have had 1, 2, 3, 4, 5. You are on your 6th case within the last 1.5 years. There's nothing at this time that you can try to negotiate with me. Do you understand?
I understand, but it's about work.
Stop. All I want is my streets to be safe.
Yes,
And
sir.
if I find that you're in danger, anything 1 iota, it's just not going to go well for you.
I understand.
Okay, do you mind giving an application and we'll have you swear to us?